Yes, thank you very much for the introduction. Maybe as an explanation why I'm on this panel is that I wrote my PhD on damages in private enforcement. So actually the tenderers against the contracting authority. And I initially thought that's what I'm going to talk about. I discovered actually it's exactly the opposite, something that I didn't consider in 5 years of research probably. So yeah, I still learned something in preparation for this panel actually. I published the book and I think this panel is really great, and I want to compliment for whoever came up with the topic, because during the research actually I realized, well, you know, public procurement and antitrust, the linkage is becoming quite high on, I would say, general policy agendas. So we have the OECD guidelines. There is a 500-page document summarizing bid rigging and public procurement issues in different countries. I think all the competition authorities have issued some kind of guidelines for procurers to detect bid rigging, so the checklists and so forth. I think the topic as such is there, but if you look for the damages claims, I can really say that it is nowhere very systematically addressed. I think there is some anecdotal evidence where, you know, country reports state that cases were dropped because contracting authorities were not convinced. We have few examples of successful damages claims, but in that policy initiative that's globally ongoing, I would say there is no systematic attention to the importance for damages claims. So in that sense, I compliment really you know, whoever identified this topic that I never thought about before. A first point that came with me being an academic is that I'm probably a little bit more theoretical, and I would really also like to make that point. I work comparatively, and I would really like to bring some thoughts forward that are more theoretical, and I will couple them with the example of Germany, because I think some meat and some cases are necessary to understand the fundamentals that are going to be common across jurisdictions, however. The first one is, well, if we think about bid rigging and public procurement, you always have to bear in mind, speaking about damages, that there is a complementarity of remedies. So you have to see that there is a whole universe of remedies that can be available. You don't just have damages. In the context of procurement procedures, there may be the exclusion from the tendering procedure for distortions of competition that could be a very effective remedy simply in terms of enforcement. We already touched upon this point that there are criminal sanctions available. For example, in Germany, there is monetary sanction and prison sentence for up to 5 years in the context of bid auctions. So you have very specific remedies of criminal nature in public procurement. Of course, you have fines. That's something, you know, that's the most common remedy, I would say. And then what we are thinking about is now, what can damages claims actually bring to the table? This is the question that we are considering, right? Can damages claims by contracting authority actually add something to this universe of remedies that we have available? And not to forget also that settlements, we don't have numbers on settlements because they are usually on the side. So this is something in terms of remedies and complementarity that we also need to bear in mind. As I said, I think the really fundamental question that we need to ask ourselves is, what can damages claims actually deliver as opposed to sanctions and fines? Because if you think about it very intuitively, maybe all those excessive, not excessive, but extensive powers granted to the state in such procedures are actually quite beneficial. And I think the answer is somewhere in the function of damages. And if we think about what damages can do, I think they have these two functions. So one is punishment of the offender, and the other one is preventing future offenses. So you have a kind of preventive function of damages. This is inherent, and I think sanctions and fines can equally effectively fulfill those functions. I don't think damages claims actually bring anything to the table on these two. I do think that damages claims by contracting authorities are better on the compensatory element, because damages claims can have a more immediate compensation effect. Because a competition authority may well fine an offender, but it doesn't mean that actually, for example, the university, that's a public contracting authority, gets the compensation immediately back. So I think there is an element where, depending on jurisdiction, there could be an advantage to damages claims in terms of function, just what they could deliver. What I would like to do now is to look at more concretely how the damages claims are actually possible under the new German legislation. So that's quite a recent one, and we are also going to consider one case and a little bit of case law to understand what the difficulties can be in claiming damages by contracting authorities. You will see that the German Competition Act was recently modified. The modifications entered into force in June 2017, so we are talking about very recent phenomena. And what we can say in summary is that there's a duty to compensate the resulting harm in Article 33 of the Antitrust Act. This duty basically always existed already before, so in that sense, just in terms of creating a damages action, the amendment does not add anything much. However, Article 33A2 adds also this rebuttable presumption that a cartel causes damage, and this is, at least in terms of the legislative text, this is an addition to the German Antitrust Act. We also have a formal recognition in Germany, as in most other jurisdictions, I would say, of the passing on defense, but the German wording of it is quite specific, so it really equals harm to price surcharges caused. So there is a specificity, I think, about the implementation of Germany in this respect. There is the quantification of damages, which can be done according to 287, and this is important because it allows for an estimation of damages, possibly. So you don't have to prove damages, but the court can proceed to estimate damages, and in practice this could be an important feature. And lastly, the German implementation chose for 5 years limitation periods, which is also pretty standard, I would say. Again, coming back to a more theoretical notion, and especially in the German implementation, we have to consider that damages actually play a twofold role in a damages claim. They can act as a constitutive criteria for establishing liability, and we have the question of quantification of what is the damage. So in the German implementation, there is a note accompanying the Antitrust Act proposal. It's assumed that the presumption in the directive actually only concerns the constitutive stage. So that means that we deal still with a lot of uncertainty at the quantification stage, because only the constitutive stage in German interpretation is then actually given as a presumption. So that means you have still a huge, let's say, problem of damages that is left unaddressed and will be able to only resolve in case law, I think. Looking now at a case, one of the, I think, most cases and most discussed cases were actually a contracting authority, so the municipality or like a city in the municipality of, in the land of Baden-Württemberg, had a procedure for firefighting vehicles. It was quite clear, there was a decision by the competition authority that there was a cartel of the 4 biggest producers, and the public procurement procedure actually had quite a low value if you compare. It was at 120,000. So that's a pretty low value if you speak about you know, some of other litigations that are being brought. So the first issue that arose is whether there is the presumption of damages. So you have to see that this predates actually the implementation that we are talking about now through the Antitrust Act amendments. And here the court was quite clear that there is a presumption of damages caused. There is a general presumption that cartels result in surcharges as well, and it also recognized the pricing umbrella effect. Now we have this Article 33A and Article 33C, and this is the passing on defense and the general damages article. And there is a legislative note accompanying it, so that note is half a page long, and it makes a very strange interpretation of the wording. It basically says that these articles supersede the old established case law. And it thereby created a lot of legal uncertainty because, first of all, the formulation of that notice is pretty open, but also now we don't know anymore whether the old case law that had been developed actually is a confirmation of the legislative article or it's not a confirmation. Because, of course, the article is new, we don't have new case law on this issue, but this notice, because you can, of course, use it for interpretation and so forth, really created an important legal uncertainty, I would say, as to what exactly now this damages claim means in Germany, and especially the presumption. So there is really an area where there is a lot of doctrine and discussion and controversy about this specific issue. Specifically because of the separation between the constitutive and the quantification stage and then the evidentiary burden. So it's very unclear how the evidentiary burden will be distributed, and the note explicitly says that the courts will have to decide on this. So we can expect some litigation on this point. The second issue that is very interesting in the firefighting cartel is that actually in that case there was a liquidated damages clause. So the damages were awarded not on the basis of the general legislation, but they were awarded on the basis of a clause contained in the general conditions of the contracting authority. So in that case, the contract contained the clause that when the contractor violated competition rules, 15% of the billing sum would be due. So this was a contractual clause included. Yeah, and so in that case, in this firefighting case, the court actually accepted the 15%, and that was quite an easy thing to do in terms of quantification. So you could see here, really in terms of quantification, the clause resulted in such legal precision and calculation that you could see that introduction of clauses might actually be a facilitation for damages claims. So yeah, maybe they make quantification of damages easy. On the other hand, in Germany, unfortunately, there is a hugely divergent case law on this issue, and there are attempts of typologizing based on procedures and so forth, but they are really court case decisions because there is firefighting vehicle 2, and they said no, there is these general clauses are not valid because the price increase may not be generalized and inferred. So there is this theoretical possibility, but we have very opposed case law on this issue. And I think, again, the implementation of the damages directive does not clarify this issue in any way. So we still have, legal uncertainty also to the contractual clauses. Speaking of that, I more abstractly, therefore, want to point out also that there is a strong link between the cause of action and the claimable damage, because we kind of spoke about damages claims a little bit unitary at this point, while it's very different whether you have damages claims arising out of contract or whether you have damages claims based on the legislation. And I think we have to think about all of them. So, for example, the contractual damages have the advantage that you can very clearly stipulate an amount of damages that you would get, and therefore the quantification stage of damages becomes much easier. That's the advantage of contractual damages. You have competition law damages. Of course, there you have the advantage that you have large, namely loss of profit damages that you could claims. So in that sense, they are beneficial. And I also would like to actually reflect on these more specific legal frameworks, and we touched upon it before, that, for example, in the US, you have the False Claims Act, and that's a very specific legislation which permits government authorities to go against companies that defraud the US government. And under these, of course, we're also talking about the US, treble damages, so triple damages, were awarded over 103 million in a sewer cartel, and actually that act is used a lot. So it's very regularly and habitually used with very high damages awards granted to the claimants. So I think in terms of how to improve the system, this is a very specific but highly effective legal instrument. And the last cause of action, maybe in this relationship, is that there's also the pre-contractual liability that could be interesting in public procurement constellations. Because if we speak about damages claims, we are talking about an ex post remedy usually. The damage has to have occurred at some point because you have to prove it. And that means that usually you will actually talk about ex post facts. But what if a contracting authority notices irregularities during a procedure? So in that sense, the damage hasn't already occurred, but maybe through culpa in contrahendo, you could actually, at an earlier stage, already use damages to enforce competition law. So these were, I think, the thoughts on different causes of actions. And to conclude, well, generally there are only very few cases, although some of them are successful. The policy documents indicate a reluctance of governments to engage in damages claims. And I think the answers we can give is that there is a lot of legal uncertainty, at least in Germany, but I think that's the case for other jurisdictions as well. We have the doubtful validity of contractual clauses, and generally speaking, of course, we also have litigation costs, so I think that's something that you really have to consider if we speak about the effectiveness of damages claims. And yeah, I think my conclusion personally is that to systematically improve enforcement, damages claims are not going to be that useful in terms of general enforcement, but I think they can be useful in terms of specific compensation issues that contracting authorities have. I think they do less for enforcement than they do actually for the compensation needs of contracting authorities. Thank you.